Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Every individual situation is unique, and laws regarding asset division and retirement accounts vary significantly by state and are subject to change. You should not act upon any information provided here without first consulting with a qualified attorney, certified financial planner, or tax professional in your specific jurisdiction. While we strive for accuracy, the complexities of the Internal Revenue Code and the Employee Retirement Income Security Act mean that errors can have significant consequences. Please conduct your own due diligence before making any decisions regarding your financial future. In the early 1980s, a specialized niche of American law began to resemble a high-stakes art gallery where the masterpieces weren't painted on canvas, but were instead etched into the ledgers of corporate retirement accounts. Imagine spending 35 years meticulously building a financial monument, a 401k account that has weathered market crashes, stagflation, and bull markets, only to realize that the most dangerous threat to that monument isn't a stock market correction, but a single incorrectly placed comma in a legal document. For many Americans, the 401k is the single largest asset they will ever own, often dwarfing the value of the family home. Yet, in the theater of U.S. divorce, it is frequently the most misunderstood and poorly handled piece of the puzzle. There is a staggering historical trend where individuals lose 40 to 50% of their projected retirement lifestyle, not because of the split itself, but because they didn't understand the art history of the Qualified Domestic Relations Order. We are looking at a landscape where a simple administrative oversight can trigger immediate tax penalties of 10% plus ordinary income tax on hundreds of thousands of dollars, effectively incinerating a decade of hard-earned savings in a single afternoon. This video is the first part of a deep dive masterclass designed to pull back the curtain on how these accounts are actually divided, the historical legislation that created this complex system, and the specific case studies that illustrate why you cannot treat a 401k like a standard savings account when a marriage dissolves. The problem we are solving today is the information gap. Most people entering a divorce in the United States view their retirement account as a monolithic block of cash. It is not. It is a highly regulated, tax-deferred vehicle governed by federal laws that often supersede state-level divorce decrees. By the end of this series, you will understand the mechanics of asset tracing, the difference between marital and separate property in the context of retirement growth, and the specific art of protecting the tax-advantaged status of your future. We are going to look at why the year 1974 changed everything for American couples, and why the accidental creation of the 401k in 1978 set the stage for the most complex legal battles of the 21st century. To understand the current state of 401k divorce, we have to look at the historical provenance of the retirement account itself. Before 1974, the American retirement landscape was the Wild West. If a company went bankrupt, the workers' pensions often vanished. This led to the passage of the Employee Retirement Income Security Act, known as ERISA. This was the foundational legislation, the old master of retirement law. However, ERISA was originally designed to protect employees from their employers, not to address the division of assets between spouses. In fact, for a decade after ERISA was passed, there was a massive legal gray area. If a state court ordered a pension to be split during a divorce, the plan administrators often refused, citing federal law that prohibited the alienation of benefits. This created a crisis where thousands of spouses were left with no access to the retirement wealth built during the marriage. This tension led to the Retirement Equity Act of 1984, which is perhaps the most significant artistic shift in the history of U.S. marital finance. This act introduced the concept of the Qualified Domestic Relations Order, or QDRO. Think of the QDRO as the official authentication papers for an expensive painting. Without a QDRO, a divorce decree is essentially powerless to move money from a 401k to an ex-spouse without triggering massive tax consequences. We have seen historical trends in case studies where one party was awarded half of a 401k in their divorce papers, but because they never filed the actual QDRO with the plan administrator, the account holder retired, took a lump sum, spent it, and the ex-spouse was left with zero recourse against the financial institution. This is a critical point. A judge's signature on your divorce settlement is not the final step. It is merely the beginning of a federal administrative process. The complexity deepens when we consider the art of valuation. Unlike a house which can be appraised by looking at recent sales in the neighborhood, a 401k is a living, breathing entity. One of the most common pitfalls in U.S. divorce history is failing to account for passive growth versus active contribution. Let us look at a potential outcome for someone who entered a marriage with a 401k, already worth $100,000. 10 years later, at the time of divorce, the account is worth $400,000. A common mistake is to assume the marital portion is $300,000. However, through the lens of forensic accounting, we must determine how much of that growth was due to the original $100,000 sitting in the market, which might remain separate property, versus how much was due to contributions made during the marriage and the growth on those specific contributions. This requires a level of detail that many generic divorce kits completely ignore. Furthermore, we must address the tax affecting of these assets. If a couple has $200,000 in a home's equity and $200,000 in a 401k, they might think they have $400,000 in total assets to split 50-50. This is a mathematical illusion. The $200,000 in the house is largely after-tax money. The $200,000 in the 401k is pre-tax. If you take $100,000 out of the 401k to balance the equity of the house, you aren't getting $100,000. After federal and state taxes, you might only be getting $70,000. This disparity has led to decades of lopsided settlements where one spouse walks away with real dollars and the other walks away with future, taxable dollars, often realizing the mistake only years later when they attempt to withdraw the funds. The art history of the 401k also involves understanding the 10% early withdrawal penalty. Normally, if you are under age 59 and a half, the IRS takes a 10% bite out of any distribution. However, the QDRO provides a unique one-time historical loophole. Under Section 72(t)(2)(c) of the Internal Revenue Code, a non-employee spouse who receives a distribution via a QDRO can actually take that money as cash without the 10% penalty, though they still owe the regular income tax. This is a strategic brushstroke that many use to pay off marital debt or secure a down payment on a new home during the transition of divorce. If the money is rolled over into an IRA first, and then withdrawn, that 10% penalty protection vanishes forever. This is why the sequence of events matters more than the total dollar amount. In the next sections of this deep dive, we will explore the specific mechanics of the valuation date. Is it the date of separation? The date of filing? The date of the final decree? In a volatile market, the difference of 30 days can mean a swing of tens of thousands of dollars. We will look at how the art of negotiation involves trading 401k assets for other marital property, and how to ensure that the plan administrator, the often ignored gatekeeper of your retirement, actually approves your masterpiece of a legal order before it's too late. The history of American divorce is littered with rejected QDROs that were sent back years after the divorce was finalized, forcing ex-spouses to return to court at great expense to fix technicalities that should have been addressed on day one. By examining these historical trends and case studies, we aim to provide you with the clarity needed to navigate these high-stakes waters. To understand the complexity of dividing a 401k in 2026, we must look at the drafting process of the Qualified Domestic Relations Order as a form of architectural restoration. If the 401k is the building, the QDRO is the blueprint that tells the plan administrator exactly how to move the heavy stone of assets without causing the entire structure to collapse under the weight of IRS penalties. Imagine a resident of Ohio named Michael in early 2026. Michael has been a dedicated software architect for 15 years, and his 401k has grown into a significant seven-figure masterpiece. His spouse, Jennifer, is entitled to a portion of this account as part of their settlement. In the world of U.S. art history, a restoration expert wouldn't just start scraping paint. They would study the chemical composition of the original layer. Similarly, Michael and Jennifer cannot simply tell the court they want to split the account. They have to navigate the anti-alienation provisions of the Employee Retirement Income Security Act. The first step in this deep dive masterclass is identifying the exact plan type, which is far more technical than it sounds. In 2026, many corporations have merged or been acquired, meaning the 401k Michael started in 2011 might now be managed by a completely different entity under a different set of summary plan descriptions. The professional script for this process begins with the request for information. This isn't a casual phone call. It is a formal demand to the plan administrator for the specific QDRO procedures and the model language that the plan prefers. Historical trends show that each major financial institution has its own unique vocabulary. If you use the language preferred by Vanguard for a plan managed by Fidelity, The plan administrator might reject the order as if it were a forged signature. Once the procedures are in hand, we enter the phase of choosing between a separate interest and a shared interest approach. This is the technical core of the 401k division art. A separate interest order effectively carves out a piece of the 401k and hands the keys to the alternate payee, in this case Jennifer. This allows Jennifer to manage her own investment choices, choose her own beneficiaries, and decide when to begin taking distributions, independent of when Michael retires. In contrast, a shared interest order is more like a shared ownership of a single painting. Jennifer would only receive payments when Michael starts receiving his. For most modern 401k accounts, which are defined contribution plans, the separate interest approach is the standard, but failing to specify this can lead to a legal limbo where assets are frozen for years. Now, let's look at the mathematical art of the valuation date. This is where many individuals see significant shifts in their potential outcomes. Imagine if Michael and Jennifer agreed to a 50-50 split on January 1, 2026. At that time, the account was worth $1.2 million. However, the legal system moves slowly. By the time the QDRO is drafted, reviewed by the plan administrator, and signed by a judge, it is June 2026. If the market has experienced a correction during those 6 months, and the account value has dropped to $1 million, does Jennifer get $600,000, half of the January value, or $500,000, half of the current value? If the order specifies a dollar amount rather than a percentage, Michael could be left with significantly less than his intended share. Step by step, a professional must include language that accounts for gains and losses from the valuation date until the date of actual distribution. Without this specific clause, the person receiving the funds might miss out on months of market growth, or the person holding the account might be forced to overpay using their remaining share. A critical and often overlooked detail in this 2026 landscape is the treatment of 401k loans. Suppose Michael took a $50,000 loan from his 401k in 2025 to fund a home renovation. When the court looks at the account balance, it sees $1,150,000 in cash and investments plus a $50,000 IOU from Michael. The plan administrator views that loan as an asset of the plan. If the QDRO says Jennifer gets 50% of the account balance, does that include 50% of the loan? Jennifer cannot be forced to pay back a loan she didn't take, but Michael shouldn't necessarily be credited for a debt that lowered the total marital pot. The artful solution requires a specific instruction in the QDRO on whether the loan balance should be included or excluded from the total valuation. Case studies indicate that ignoring the loan balance is one of the top 3 reasons for post-divorce litigation in the United States. Then there is the matter of the plan administrator's role as the curator of the asset. The administrator has a fiduciary duty to the plan, not to Michael or Jennifer. They are the final gatekeepers. Once the QDRO is drafted, it should be submitted for a pre-approval process. This is the stage where the administrator reviews the document for any technical flaws that would prevent it from being qualified under federal law. In 2026, many administrators use automated systems to scan for specific keywords. If a single required element, such as the social security numbers or the exact legal name of the plan, is missing or formatted incorrectly, the order is rejected. This leads to a cycle of revision that can cost thousands in additional legal fees. This is why the masterclass approach emphasizes getting the model language directly from the source before the first draft is even written. We also have to consider the surviving spouse protections. In the history of U.S. retirement law, the rights of a current spouse often overwrite the intentions of the account holder. If Michael were to pass away after the divorce is finalized but before the QDRO is officially qualified by the plan, Jennifer could potentially lose her entire claim to the account unless the QDRO includes a specific provision naming her as the surviving spouse for her portion of the benefits. This is known as the nunc pro tunc or now for then issue. A professional scriptwriter for these legal documents must ensure that the order is drafted to protect the alternate payee during this vulnerable shadow period between the divorce decree and the finalization of the account split. Consider a historical trend where individuals assumed that once the judge signed the papers, the work was done. In reality, the transfer of 401k funds often takes 90 days or more after the administrator receives the court-certified order. During this time, the assets are often placed in a hold or a segregated account, meaning they might be moved out of high-growth tech stocks and into stable value funds. If Michael and Jennifer are not aware of this, they might be surprised to find that their assets didn't move with the market during the final transition phase. This administrative freeze is a mandatory part of the process, designed to prevent the participant from liquidating the account before the alternate payee gets their share. As we move deeper into this masterclass, the stakes only get higher. We have mapped out the blueprint and the administrative hurdles. But what happens when the 401k contains assets that aren't easily liquidated? What if Michael's company offered a specialized tier of private equity or company stock within the 401k that has strict vesting schedules or blackout periods? The division of these specific pigments in our financial painting requires an even more sophisticated level of tracing and tax planning. This brings us to a massive looming question that haunts almost every high-asset divorce in the US today. What happens if the plan administrator says the QDRO is invalid because of a conflict with the company's internal policy, even if a state judge already ordered it? And more importantly, how do you handle the hidden shadow taxes that can strip away 30% of your settlement before you even see a dime? In the next part, we will break down the precise tax strategies used to neutralize these threats and look at the tracing nightmare, where premarital funds and marital growth become so intertwined that it takes a forensic historian to separate them. We will also examine the specific 2026 tax code updates that could change the way you look at your retirement statement forever. To master the art of the 401k divorce in 2026, one must become a forensic historian of their own financial life. The tracing nightmare begins the moment a premarital asset is introduced into a marital environment. Imagine a professional in Seattle named David. In 2014, long before he met his spouse, Linda, David had already built a 401k worth $150,000 through his work at a major tech firm. When they married in 2016, David didn't stop contributing. He continued to add $20,000 a year, and his employer matched a percentage of that. By the time 2026 arrives and the couple decides to part ways, that account has ballooned to $850,000. To the untrained eye, this looks like a simple $850,000 asset. To a forensic accountant, this is a layered canvas where the original $150,000 is the base primer, and every subsequent contribution is a new stroke of paint that has been blended, smudged, and glazed by market fluctuations. The first step in David's case is identifying the separate property component. In many jurisdictions across the United States, the $150,000 David brought into the marriage is considered his separate property. However, it is not as simple as subtracting $150,000 from $850,000 and splitting the remaining $700,000. We have to account for the passive growth on that original $150,000. This is where historical trends in case law come into play. If that original money was invested in an S&P 500 index fund that doubled in value during the marriage, David could potentially argue that $300,000 of the current balance is his separate property, even if he never added another cent to that specific portion of the fund. This is the art of passive appreciation. But the burden of proof is on David. He must produce the statements from 2016 to prove the starting balance and the specific investment allocations. If those records are lost to time or a defunct online portal, the court may default to treating the entire account as marital property. This is a potential outcome that creates a devastating financial loss for the original account holder. Step by step, the tracing process involves a calculation known as the coverture fraction or the time rule formula. Though in 401k cases, a more precise tracing of contributions is often preferred. Imagine if David had rolled over his old 401k into his current employer's plan in 2018. This act of commingling is like pouring a bottle of vintage red wine into a vat of modern table wine. You can no longer easily separate the molecules. Forensic accountants use a method called the unit tracking approach. They look at how many units of a specific mutual fund were owned on the date of marriage and track those specific units through every stock split, dividend reinvestment, and rebalance. If the plan administrator changed from Fidelity to Vanguard in 2021, the trail becomes even colder. This requires a deep dive into the historical records of the plan's summary plan description and individual transaction histories. Now let's layer in the specific complexities of 2026 tax law. We are currently operating under the full implementation of the Secure 2.0 Act, which introduced significant changes to how catch-up contributions are handled. Starting in 2026, for individuals earning over $145,000, catch-up contributions to a 401k must be made on a Roth basis. This means David's 401k is no longer just a pre-tax bucket. It is now a hybrid account containing both pre-tax and post-tax dollars. When a judge orders a 50-50 split of the 401k, the QDRO must be extraordinarily specific about which dollars are being moved. If Linda receives $425,000 of pre-tax money, while David keeps $425,000 that includes a significant portion of Roth contributions, the split is fundamentally unequal. Linda will owe ordinary income tax on every dollar she withdraws in retirement, while David will enjoy tax-free growth on his Roth portion. In the high-stakes world of 2026 asset division, failing to distinguish between traditional and Roth subaccounts within a single 401k is a catastrophic oversight that can result in a 30% discrepancy in the actual realized value of the settlement. Furthermore, we must address the 2026 reality of required minimum distributions. The Secure 2.0 Act pushed the RMD age to 75 for some individuals. If one spouse is significantly older than the other, the timeline for when that 401k money must be withdrawn and tax changes the present value of the asset. A forensic historian must calculate the tax-adjusted present value. This involves looking at the life expectancy of both parties and their projected tax brackets in retirement. If Linda expects to be in a lower tax bracket than David, she might actually prefer the pre-tax 401k assets because her tax liability will be lower than his would have been. This creates a scenario for a strategic trade. David might give Linda a larger share of the 401k in exchange for keeping the entirety of a brokerage account that holds capital gain-sensitive assets. This is the art of the offset. Consider a case study involving a character named Robert in New York. Robert has a 401k with a heavy concentration in company stock. In 2026, his company's stock has seen extreme volatility. The 401k plan allows for something called net unrealized appreciation, or NUA. This is a sophisticated tax strategy where the growth on company stock can be taxed at the lower capital gains rate rather than the higher ordinary income tax rate when distributed. If the QDRO simply transfers half the shares to his ex-spouse, Sarah, without considering the NUA implications, the tax-advantaged status of those shares might be jeopardized. The QDRO must be drafted to allow Sarah to step into Robert's shoes regarding the cost basis of those shares. If the order is silent, the plan administrator might liquidate the shares to cash during the transfer, effectively destroying the NUA benefit and triggering a massive tax bill for Sarah that she never anticipated. This brings us to the danger of the outstanding 401k loan in 2026. In our current economic climate, more Americans are borrowing against their futures. If David has a $50,000 loan outstanding, the plan administrator sees that loan as an asset, but the IRS sees it as a potential distribution. If the divorce decree says the account is split equally, and David fails to pay back the loan before the QDRO is processed, the loan might be deemed a taxable distribution to him. However, if the QDRO is not careful, it might inadvertently assign a portion of that tax liability to Linda. Historical trends in 2026 show that plan administrators are becoming more rigid. Some plans require the loan to be paid in full before any QDRO can be processed. If the couple doesn't have $50,000 in cash to bridge that gap, the 401k division can be paralyzed for years, leaving both parties in a state of financial suspended animation. We also have to look at the historical provenance of the vesting schedule. If David's $850,000 balance includes $100,000 of unvested employer matches, that money isn't legally his yet. Most state laws consider the unvested portion to be marital property if the work was performed during the marriage. However, a 401k plan administrator cannot transfer unvested money to an ex-spouse via a QDRO. The order must include a specific formula for what happens when those funds eventually vest. Does Linda get a percentage of whatever eventually vests, or is she limited to a percentage of what was vested on the day of the divorce? This is the difference between a static photograph of an asset and a time-lapse film. The complexity of these future assets requires a QDRO that is essentially a living document, capable of handling events that haven't happened yet. As we conclude this part of our masterclass, we have unraveled the layers of tracing, tax hybridization, and the hidden traps of company stock and loans. But even if you perfectly calculate the value and perfectly draft the tracing, there is a hidden phantom that can still haunt your retirement: the plan expense and the investment choice. What happens if the person who keeps the 401k changes the investment strategy to something incredibly risky while the QDRO is pending? What if the plan charges a $5,000 administrative fee just to process the QDRO? And most importantly, how do you handle the situation where the 401k isn't just a 401k, but part of a multi-tiered retirement package involving non-qualified deferred compensation plans that a standard QDRO cannot touch? In the next part, we are going to dive into the shadow accounts. These are the executive-level retirement vehicles that often mirror a 401k, but are governed by entirely different sets of laws. We will look at why a QDRO is completely useless for these assets and the specific alternative orders you need to secure your share of a high earner's future. We will also break down the step-by-step process of the internal rollover versus the external transfer, and which one will save you the most in management fees over the next 20 years. The art of the 401k divorce is about more than just the split. It is about who controls the canvas after the artist has left the studio. Entering the world of shadow accounts requires us to move past the well-lit corridors of standard 401k plans and into the more obscure executive suites of American finance. In 2026, many high-earning professionals in the United States, such as corporate executives, physicians, or senior partners at law firms, have retirement strategies that extend far beyond the legal limits of a 401k. These are known as non-qualified deferred compensation plans, or NQDCs. Imagine a resident of California named James who has spent 20 years climbing the ladder at a Fortune 500 company. While James has a 401k worth $1 million, he also has a shadow account, a deferred compensation plan worth $3 million. In the heat of a divorce, his spouse, Sarah, might assume that a standard qualified domestic relations order will split both. This is a critical misunderstanding of the art of asset division, because, historically, QDROs only apply to plans governed by the Employee Retirement Income Security Act. NQDCs are not governed by ERISA. They are essentially private contracts between an employer and an employee. If Sarah tries to serve a QDRO on James's deferred compensation plan, the plan administrator will likely reject it immediately. This is because these plans are technically unsecured liabilities of the company. In the eyes of the law, the money in a shadow account doesn't actually belong to James yet. It is a promise from the company to pay him at a later date. This creates a massive hurdle in a 2026 divorce because you cannot easily carve out a piece of a promise to give to an ex-spouse. Case studies show that when these assets are overlooked or mishandled, the non-employee spouse may walk away with significantly less than their intended share, unaware that the largest portion of the retirement wealth was hidden in plain sight. To address this, legal professionals must use what is often called a domestic relations order, or a specialized settlement agreement that mirrors the function of a QDRO, but operates under contract law rather than federal pension law. The complexity of these shadow accounts is further intensified by Section 409A of the Internal Revenue Code. This specific piece of tax history is the hidden trap of executive divorce. Section 409A dictates exactly when and how deferred compensation can be paid out. If a divorce settlement accidentally triggers a violation of 409A, for example, by trying to force an immediate payout of the deferred funds to the ex-spouse, the IRS can impose a 20% penalty plus interest on top of ordinary income taxes. Step by step, the division of an NQDC requires a forensic analysis of the plan document to see if it even allows for a transfer of interest to an ex-spouse. If the plan is silent or explicitly prohibits transfers, the only potential outcome is for James to keep the plan and buy out Sarah using other marital assets, such as the equity in their home or a larger share of the standard 401k. Now, let us look at the pivotal choice between an internal rollover and an external transfer of the actual 401k assets. Once the QDRO for the standard 401k is approved, the recipient, Sarah, faces a decision that will impact her financial landscape for the next 20 years. An internal rollover means Sarah keeps her share of the money inside James's employer-sponsored plan, but in her own name. An external transfer means she moves the money into her own individual retirement account. Historical trends in 2026 suggest that many individuals rush to move the money out to gain a sense of closure and control, but this can be a costly mistake. The primary advantage of the internal rollover is access to institutional class shares. Large 401k plans, like those at major tech or manufacturing firms, often have access to mutual fund share classes that are not available to the general public. These shares often have significantly lower expense ratios. For example, a retail class S&P 500 index fund in an IRA might charge an expense ratio of 0.15%, while the institutional version inside a massive 401k might charge only 0.02%. On a $500,000 balance, that small difference in the brushstroke of management fees can save Sarah tens of thousands of dollars over 2 decades. Furthermore, assets held within a 401k generally enjoy stronger federal protection from creditors under ERISA than assets held in an IRA, which are subject to varying state laws. However, The external transfer to an IRA offers the artistic freedom of a much broader investment universe. While a 401k might limit Sarah to 20 or 30 specific mutual funds, an IRA allows her to invest in almost anything: individual stocks, specialized ETFs, or even certain types of real estate. The step-by-step process for this move must be handled as a direct rollover. If the plan administrator cuts a check directly to Sarah instead of the financial institution holding her new IRA, they are legally required to withhold 20% for federal taxes. Even if she eventually puts the money into an IRA, she would have to come up with that 20% out of her own pocket to avoid it being treated as a taxable distribution. This is a logistical minefield where a single misstep can create an immediate cash flow crisis during an already stressful divorce. We must also consider the 2026 implications of the catch-up provisions we touched on earlier. For high earners over age 50, the requirement to make catch-up contributions to a Roth account means that many 401ks are becoming increasingly fragmented. When Sarah receives her portion, she must ensure the plan administrator accurately tracks the cost basis of the Roth portion versus the traditional portion. If the plan administrator simply dumps everything into a traditional IRA, Sarah could lose the tax-free status of those Roth contributions, effectively paying taxes twice on the same money. This level of detail requires the QDRO to specify that the transfer must maintain the tax characteristics of the sub-accounts. Imagine a scenario where James had a supplemental executive retirement plan, often called a SERP. These are the most elite of the shadow accounts. They are often top hat plans that provide benefits to a select group of management. Unlike a 401k, a SERP might not have an actual account balance. It might be a formula based on years of service and final salary. Valuing a SRP in 2026 is like trying to value a painting that hasn't been finished yet. A forensic actuary must be brought in to calculate the present value of that future stream of income, taking into account James's health, the company's financial stability, and projected inflation. If the divorce occurs before the SRP is vested, the risk of the asset never paying out must be factored into the split. Case studies show that spouses who demand a percentage of a future SRP payment often find themselves in conflict with the company's vesting rules, which may stipulate that the benefit is lost if the employee leaves the company before a certain age. As we master these complexities, we find that the true art of the 401k divorce isn't just in the division of the present, but in the protection of the future. The choices made during the QDRO drafting, choosing between internal and external transfers, identifying shadow accounts, and navigating the 409A tax traps, determine whether the financial masterpiece you built together remains intact or is slowly eroded by fees, taxes, and penalties. But even with the most perfect QDRO and the most sophisticated tax strategy, there is a looming threat that can bypass all of these protections. What happens if the person who currently holds the 401k decides to liquidate the entire account or take a massive loan the day before the judge signs the order? And what about the hidden beneficiaries? The individuals named on the account years ago who could still legally claim the money even after the divorce is finalized. In the next part, we will dive into the freezes and joinders, the legal maneuvers used to lock down an account the moment a divorce is filed to prevent the asset from vanishing. We will also explore the beneficiary time bomb and the specific federal laws that can override your divorce decree and hand your retirement to someone you haven't spoken to in a decade. We are moving from the history of the asset into the active defense of your future. To secure the future of a 401k during a 2026 divorce, one must understand that the legal system often moves at the speed of a museum's restoration project, while a digital bank account moves at the speed of light. This discrepancy creates a dangerous window of vulnerability where a retirement masterpiece can be vandalized before the court even appoints a curator. We begin this defense with the concept of the account freeze, a maneuver designed to preserve the status quo. Imagine a scenario in a busy suburb of Dallas, Texas, where a project manager named Mark has spent 24 years building a 401k worth $900,000. His spouse, Elena, has contributed to the household as a freelance consultant, but the 401k is the primary engine of their shared future. The moment the divorce petition is served in 2026, a clock begins to tick. In many states, something called automatic temporary restraining orders or ATROs go into effect immediately. These are the equivalent of the velvet ropes and security sensors in a gallery. They legally prohibit either party from hiding, transferring, or dissipating marital assets. However, the limitation of an ATRO is that it is often a paper shield. If Mark logs into his mobile app and initiates a maximum loan or changes his investment allocation to highly speculative digital assets that crash overnight, the damage is done before Elena can even alert her attorney. This leads us to the critical step of the joinder of the employee benefit plan. While an ATRO binds the spouses, it does not necessarily bind the 401k plan administrator, who is a third-party fiduciary. In the art history of U.S. law, the joinder is the process of making the 401k plan itself a party to the divorce action. By joining the plan, the court gains direct jurisdiction over the administrator. Step by step, this involves filing a specific set of documents that notify the company that a portion of the 401k is now under the court's supervision. Once a plan is joined, the administrator is legally restricted from processing any loans, withdrawals, or distributions until the court provides further instruction. Historical trends show that spouses who fail to join the plan are at a significant disadvantage if the account holder decides to be malicious. In 2026, where a hardship withdrawal can be approved and wired in 48 hours, the joinder is not just a formality, it is an emergency brake. We must then confront the most terrifying ghost in the history of U.S. retirement law, the beneficiary time bomb. This is where the concept of ERISA preemption becomes a reality. To understand this, we look at the 2001 Supreme Court case of Egelhoff versus Egelhoff. This case established that federal law, specifically the Employee Retirement Income Security Act, overrides state laws regarding beneficiary designations. Imagine if Mark and Elena were married for 20 years, but Mark never updated the beneficiary form he filled out when he was 22 and dating a woman named Samantha. Even if Mark and Elena's divorce decree clearly states that Elena is entitled to the 401k and that any previous beneficiaries are revoked, if Mark dies before the QDRO is finalized and Samantha is still on that piece of paper, the plan administrator is legally required to pay the money to Samantha. The Supreme Court ruled that the plan administrator should not have to act as a detective searching through state divorce decrees. They only have to follow the documents on file with the plan. In 2026, this remains the law of the land. A divorce decree is essentially invisible to a 401k plan administrator until a QDRO is qualified. Case studies from the last 2 decades illustrate a heartbreaking pattern. An ex-spouse wins the 401k in court, the account holder dies a month later, and the money goes to an ex-girlfriend, a sibling, or a parent from 30 years ago because the beneficiary form was never updated. This is why the active defense of your future requires an immediate demand for a copy of the current beneficiary designation. If you are the spouse who is not the account holder, you must ensure that a QDRO is not just written but qualified as quickly as possible. The QDRO acts as a permanent update to the beneficiary status. Until that document is stamped by the plan administrator, you are standing in a gallery where the doors are unlocked and the security cameras are turned off. Another nuance of the 2026 landscape is the role of the 401k loan during the cooling-off period. If Mark takes a $50,000 loan from his 401k 2 weeks before filing for divorce, he has effectively created a lien against the art. In a deep dive analysis, the court must decide how to treat this debt. If the money was used for a marital purpose, such as repairing the family roof, the debt is shared. But if Mark used the loan to fund a private investment or to prepay his legal fees, the court may attribute the entire loan to his share of the asset. The mathematical art here involves a process called the gross up. If the account is worth $500,000 but has a $50,000 loan, the court may treat it as a $550,000 asset for the purpose of the split, awarding Elena $275,000 of the actual cash and leaving Mark with $225,000 plus the obligation to pay back his own $50,000 debt. We also have to account for the 2026 reality of participant-directed brokerage accounts within 401ks. Many modern plans allow employees to move their 401k money into a self-directed brokerage window to buy individual stocks or even cryptocurrencies. This creates a tracing nightmare during the freeze. If Mark moves the 401k money into a high-risk tech stock during the divorce and that stock drops 60%, who bears the loss? Historical trends in 2026 courts show a lean toward the principle of breach of fiduciary duty between spouses. If one spouse makes a unilateral, high-risk investment decision with marital retirement funds while a divorce is pending, the court can order that the loss be taken entirely out of that spouse's share. This is the equivalent of a gallery owner being held responsible for damage if they decide to store a Renaissance painting in a damp basement during a sale. The complexity intensifies when we look at the specific language required for the preliminary injunction. A general order to not touch the money is often too vague. A A professional defense requires an order that specifies the exact account numbers and forbids not just withdrawals, but also changes in investment elections that would significantly alter the risk profile of the account. In the high-stakes environment of 2026, where market volatility can swing 10% in a single week, the ability to control the investment direction of the 401k during the divorce is as important as the final split itself. If Elena is 20 years younger than Mark, she has a much higher risk tolerance. If Mark is nearing retirement, he may want to move everything to stable value funds. If they cannot agree, the account sits in a state of paralysis, potentially missing out on a historic bull market or being crushed by a sudden downturn. As we master the defense of these assets, we realize that the QDRO is the final seal on the vault. But what happens if the vault itself is empty? What if the 401k isn't a 401k at all, but a 403b, a 457 plan, or a thrift savings plan for federal employees? Each of these has a completely different historical lineage and a completely different set of rules for how they can be frozen and divided. The federal government, for instance, does not use QDROs. They use something called a court order acceptable for processing, or COAP. If you use the wrong terminology, your defense collapses. But there is an even deeper level to this art history. What happens when the retirement account is located outside the United States? In our globalized 2026 economy, many American couples have international 401ks, or offshore pension schemes that standard U.S. courts may have no power to freeze. How do you lock down an asset that is governed by the laws of London, Singapore, or the Cayman Islands? And more importantly, how do you prevent a spouse from simply rolling the 401k into an IRA and then vanishing with the cash? In the next part, we will dive into the international escape hatch and the specific maneuvers used to capture global retirement assets. We will also break down the IRA rollover trap and show you the exact moment when your 401k protections evaporate, leaving you exposed to the most common retirement heist in the United States. The defense is about to go global. The most dangerous moment in the history of a 401k divorce occurs when the asset transitions from a fortress to a suitcase. This is known as the IRA rollover trap, and in the landscape of 2026, it is the most common method used to execute what is colloquially known as a retirement heist. To understand this, we have to look at the change in legal jurisdiction. As long as Mark's $900,000 remains in his employer-sponsored 401k, it is a federally protected asset under the Employee Retirement Income Security Act. The plan administrator acts as a neutral third-party fiduciary who must follow the strict rules of a qualified domestic relations order. However, the moment Mark rolls that money over into an individual retirement account, the federal shield of ERISA evaporates. The money is no longer governed by the Department of Labor. It is now governed by state law and the internal policies of a private bank. Imagine if Mark, seeing the divorce proceedings on the horizon in early 2026, decides to leave his job or simply utilizes a portable feature of his plan to roll his 401k into a self-directed IRA. For Elena, the non-employee spouse, this is a catastrophic shift in the art of the split. In a 401k, the plan administrator would have been required to freeze the account upon receiving notice of the divorce. In an IRA, Mark often has total control. He can change the investment strategy to highly illiquid assets, take distributions that are harder to track, or move the funds to a different institution entirely. Historically, the QDRO does not apply to an IRA. Instead, the division must be handled as a transfer incident to divorce under Section 408 of the Internal Revenue Code. While this sounds like a simple distinction, the procedural gap is where assets vanish. Without a plan administrator acting as a gatekeeper, Elena is forced to rely on the court's ability to enforce its orders against Mark personally, rather than against a multi-billion-dollar financial institution. Step by step, the prevention of the IRA rollover trap requires an immediate filing of a qualified domestic relations order draft or a joinder the moment the divorce is initiated. If Mark has already moved the money, the legal strategy must pivot to a forensic tracing of the rollover. Case studies in 2026 show that sophisticated account holders often attempt to mask the origin of the funds by mixing the 401k rollover with existing IRA assets, or using the cash to purchase non-traditional investments like private equity or fractional shares of physical assets. This is the financial equivalent of taking a masterpiece and painting over it with a different scene. To reveal the original work, Elena's team must issue subpoenas to the former 401k plan administrator to prove the date and amount of the rollover, ensuring that the tax-deferred nature of the asset is preserved during the move. The complexity reaches a global scale when we consider the international escape hatch. In our 2026 economy, many American professionals have served time in overseas offices, accumulating retirement credits in foreign pension schemes. Consider a character named Chloe, a senior executive who spent 6 years in London before returning to the United States. She has a standard US 401k, but she also holds a significant balance in a UK-based self-invested personal pension or SIPP. When she divorces her spouse in a US court, the judge might order a 50-50 split of all retirement assets. However, a US judge has no jurisdiction over a UK pension provider. A QDRO is a purely American legal instrument. It has no power in London, Singapore, or Sydney. The art history of international asset division requires a maneuver known as the mirror order. This is a multi-step process where the parties must first obtain a US divorce decree, then hire a solicitor in the foreign jurisdiction to present that decree to a local court. In the UK, for example, they would need a pension sharing order. The historical trend in these cases is a massive loss of value due to currency fluctuations and shadow taxes. If the US court values Chloe's UK pension on January 1, 2026, using the exchange rate of the British pound to the US dollar, but the actual transfer doesn't occur until June, a 5% shift in the currency market can result in a $40,000 discrepancy. Furthermore, the IRS may not recognize the foreign transfer as tax-free. Under the US-UK tax treaty, there are specific protections for pensions, but if the transfer is not handled with surgical precision, the IRS could treat the division as a taxable distribution, hitting the recipient with a 37% tax bill plus an international reporting penalty. Now let's look at the other 401ks that populate the American public sector and nonprofit worlds. The 403b, the 457, and the Thrift Savings Plan or TSP. Each of these is a different school of art with its own rigid rules. The 403b plans, common for teachers and hospital staff, often mirror 401ks, but frequently involve annuity contracts that are significantly harder to split. A 401k is usually liquid. An annuity might have surrender charges that eat 10% of the value if you try to carve out a portion for an ex-spouse. The 457 plans, used by state and local government employees, have a unique historical quirk. They often allow for distributions immediately upon divorce or separation from service without the 10% early withdrawal penalty that applies to 401ks. For a spouse in 2026 who needs immediate liquidity to set up a new household, the 457 is the most valuable asset in the portfolio. Yet it is often traded away for a 401k of the same face value because the parties don't understand the liquidity premium of the 457. The Thrift Savings Plan for federal employees and members of the military is perhaps the most difficult to master. The TSP does not accept a QDRO. They require a court order acceptable for processing or COAP. The Federal Retirement Thrift Investment Board is notorious for its lack of flexibility. If a COAP uses the word 401k instead of TSP, or if it fails to explicitly state whether the split includes the tax-exempt portion of the account, common in military TSPs for combat zone pay, the order will be rejected. This rejection often takes 60 to 90 days to process, meaning that by the time the mistake is discovered, the market could have shifted significantly, or the participant could have retired and begun taking payments, complicating the split even further. Data from 2026 indicates that nearly 15% of all retirement asset divisions in the U.S. involve at least one of these non-standard plans. The step-by-step masterclass for these assets involves a 3-tier verification. First, obtaining the specific model order from the plan itself. Second, verifying the vesting status of any employer contributions. And third, performing a tax impact analysis to ensure that $1 in a TSP is being treated the same as $1 in a 403b. If you trade $50,000 of a 457 plan for $50,000 of a 403b, you may be making a massive tactical error because of the penalty-free withdrawal rules of the 457. As we conclude this exploration of the heists and escape hatches, we have seen how the 401k can be transformed into an IRA to bypass protections, how international pensions require mirror orders to capture, and how the alphabet soup of 403b, 457, and TSP plans each requires a specialized legal brushstroke. But even if you perfectly capture every asset across every border, there is one final silent predator that can still take everything. What happens when the 401k owner doesn't just try to hide the money, but files for bankruptcy in the middle of the divorce? And what about the QDRO processing fees that can reach $5,000 per account? quietly siphoning off the very wealth you are trying to divide. In the next part, we are going to dive into the bankruptcy collision. We will look at why a 401k is usually safe from creditors, but can become a bloodbath when a divorce and a Chapter 7 filing happen at the same time. We will also break down the fee schedule secrets of major plan administrators and show you how to negotiate who pays for the cost of division. We are moving into the final stages of the masterclass, where the legal architecture meets the harsh reality of the balance sheet. The collision between bankruptcy and a 401k in the middle of a U.S. divorce is one of the most complex chapters in the art history of American finance. In the landscape of 2026, where economic shifts have led to fluctuating debt levels for many families, this scenario is no longer a rare outlier but a significant historical trend. Imagine a resident of Florida named Marcus. Marcus has spent his career in the shipping industry and has a 401k valued at $600,000. However, due to a series of unsuccessful personal business ventures, Marcus is also carrying $400,000 in unsecured consumer debt. As his divorce from his spouse, Elena, proceeds, Marcus decides to file for Chapter 7 bankruptcy. For Elena, this feels like a sudden tear in the canvas of their marital settlement. She fears that his creditors will descend upon the 401k and leave her with nothing. To understand the potential outcomes for someone like Elena, we have to look back at the historical provenance of the 1992 Supreme Court case Patterson v. Shumate. This landmark decision established that the anti-alienation provisions of the Employee Retirement Income Security Act essentially make a 401k a bulletproof asset in a bankruptcy proceeding. In 2026, this protection remains a cornerstone of the retirement landscape. Marcus's creditors cannot touch the $600,000 because it is held in a qualified plan. However, the true art of the situation lies in how the bankruptcy court views Elena's claim to the account. Because a qualified domestic relations order creates a proprietary interest in the account for the ex-spouse, Elena is not considered a mere creditor. She is considered a part owner of the asset. Historical trends in bankruptcy courts show that an ex-spouse's interest in a 401k typically survives the bankruptcy discharge of the participant. This means that even if Marcus wipes out his $400,000 in debt, he cannot wipe out Elena's right to her share of the 401k. However, the step-by-step reality of this collision requires immediate legal synchronization. If the bankruptcy is filed before the QDRO is finalized, the automatic stay of the bankruptcy court may temporarily freeze the divorce proceedings. This is the legal equivalent of a gallery being locked during a police investigation. No assets can move until the bankruptcy trustee determines what is exempt and what is not. In 2026, a sophisticated legal team must file a motion for relief from the stay to allow the state court to finish the 401k division. If this step is missed and Marcus receives his bankruptcy discharge before the QDRO is entered, a potential outcome is a secondary legal battle over whether the debt to the ex-spouse was actually a domestic support obligation, which is non-dischargeable, or a simple property division, which in some specific Chapter 13 cases might be treated differently. Moving from the bankruptcy courts to the administrative offices of the 401k plan, we encounter the fee schedule secrets. Every major financial institution in the United States, from Fidelity to Charles Schwab, acts as the curator of these retirement masterpieces, and they do not work for free. In 2026, the cost of processing a QDRO has become a significant factor in the overall balance sheet of a divorce. Historical trends indicate that these fees have risen as the complexity of 401k plans, incorporating traditional, Roth, and company stock components, has increased. Imagine a case study involving a character named Olivia, who is a nurse in Illinois. Her 401k is managed by a large third-party administrator. When her attorney submits the QDRO for review, the administrator reveals a $2,000 processing fee. The art of the negotiation here involves determining who pays this fee. Most summary plan descriptions, which act as the rulebook for the 401k, state that the plan has the right to charge the participant's account for the cost of processing a QDRO. If the divorce settlement is silent on this issue, the default potential outcome is that the $2,000 is deducted directly from Olivia's remaining balance or split proportionally between her and her ex-spouse. In a masterclass approach to this problem, the settlement agreement should explicitly state how these fees are allocated. If Olivia is giving her ex-spouse a specific dollar amount, such as $100,000, she must negotiate whether that $100,000 is net of fees or if the ex-spouse must bear their own portion of the administrative cost. Furthermore, There is a hidden layer to these fees known as the model language premium. In 2026, many plan administrators offer pre-approved model QDRO language. If you use their exact template, the fee might be $500. If your attorney insists on custom language to address specific tax issues or market gain and loss calculations, the fee can jump to $3,000 or more. This is because a human legal reviewer at the financial institution must then manually verify that the custom language does not violate the plan's governing documents. Step by step, a professional must weigh the cost of the fee against the value of the custom protection. For a $50,000 account, a $3,000 fee is a 6% loss before the money even moves. For a $5 million account, that same fee is a negligible cost for ensuring the tax-deferred status of a massive transfer. The negotiation of the cost of division also extends to the actuary and the forensic accountant. If the 401k contains unvested shares or requires a complex tracing of premarital versus marital contributions, an expert witness must be hired to create a report. In 2026, these experts charge between $300 and $700 per hour. We have seen case studies where the cost of proving a $20,000 separate property claim ended up costing $15,000 in professional fees. This is the point where the art of the 401k divorce meets the cold math of the balance sheet. A strategic negotiator must perform a cost-benefit analysis before diving into a deep forensic audit of a 401k that was started in the early 2000s. Another critical 2026 detail is the treatment of administrative expenses during the freeze period. As we discussed in earlier parts, once a joinder is filed or a draft QDRO is submitted, the account is often placed in a hold status. During this time, the plan still incurs management fees and investment expenses. If the account is being split 50-50, are these expenses shared equally? If the account holder, like Marcus, was the one who made the investment choices that led to high management fees, Elena might argue that her share should be calculated based on the gross value before those fees were deducted. This granular level of detail is what separates a standard divorce from a masterclass execution. Consider a historical trend where individuals ignored the plan expenses during the valuation. If a 401k is invested in a collective investment trust that charges a high wrap fee, and the divorce takes 2 years to finalize, those fees can erode several percentage points of the total value. The QDRO should specify whether the alternate payee receives a percentage of the account as of a certain date, adjusted for gains and losses, and whether those gains and losses are net of all plan-level fees and expenses. Without this specificity, the two parties are essentially arguing over the value of a painting, while the frame is slowly being sold off piece by piece to pay for the gallery's electricity. As we move into the final stages of our masterclass, we have cleared the hurdles of bankruptcy and the hidden costs of administration. But there is one final, massive variable that can fundamentally change the value of the 401k transfer. What happens when the transfer is finalized, the money is moved, and the recipient realizes they have no idea how to manage the tax liability of the eventual withdrawals? And more importantly, what if the 401k was actually used as collateral for a private loan that the plan administrator didn't know about? In the next part, we will dive into the collateralized conflict. We will look at how private debts can suddenly appear and threaten the 401k transfer, even after the QDRO is qualified. We will also explore the post-divorce tax audit and the specific IRS forms you must file to ensure you don't get a surprise bill 3 years after the split is finalized. The art of the divorce is coming to a close, but the legacy of the asset is just beginning. The legacy of a 401k after a divorce is often decided in the quiet, paper-heavy aftermath known as the post-divorce tax audit period. In the art history of American finance, if the QDRO is the restoration of the painting, the IRS forms are the official cataloging in the National Registry. If the cataloging is wrong, the masterpiece is labeled a forgery, and the tax authorities will come to collect their due with interest. Imagine a resident of Maryland named Samantha in the year 2026. She has successfully navigated the legal labyrinth, her QDRO has been qualified by the plan administrator, and $350,000 has been carved out of her ex-spouse Gregory's 401k. To Samantha, the battle is over. She sees the balance in her new account and breathes a sigh of relief. However, she is now entering the most critical 3-year window of her financial life. The first silent predator Samantha must face is the collateralized conflict. In a potential outcome that surfaces in high-stakes historical trends, the participant, Gregory, might have used his 401k as informal collateral for a private business loan or a handshake agreement with a third party. While ERISA plans are generally protected from outside creditors, a private agreement where Gregory pledged his future distributions as a source of repayment can create a secondary legal lien that does not appear on the monthly 401k statement. When the plan administrator moves the money to Samantha, the private lender may emerge, claiming that Gregory has breached his contract. In 2026, where private credit and peer-to-peer lending have become more sophisticated, these shadow liens are becoming a common hurdle. Samantha's legal team must ensure that the settlement agreement includes an indemnity clause, essentially a legal warranty, stating that the assets are free of any undisclosed encumbrances. Without this, Samantha could find herself in a secondary lawsuit, defending her share of the retirement from a creditor she never knew existed. Once the money moves, the focus shifts to the IRS reporting cycle. This is where the step-by-step mechanics of tax forms become the primary concern. In January of 2027, Samantha will receive Form 1099-R from the plan administrator. This form is the official announcement to the IRS of how much money moved and why. The art of this form lies in Box 7, the distribution code. This single letter or number determines if Samantha owes 40% of her settlement to the government or zero. Historical trends show that a significant number of 1099-RS are issued with the wrong code. If the code indicates a premature distribution without an exception, the IRS computer will automatically flag Samantha's return for an audit. Samantha must look for Code 2, which signifies an early distribution where an exception applies, or Code G, which represents a direct rollover to an IRA. If the form shows Code 1, which stands for an early distribution with no known exception, Samantha is in immediate danger of a massive tax bill. If Samantha decided to take a portion of the 401k as cash to pay for her new home or legal fees, she must utilize the Section 72T(2)(c) exception of the Internal Revenue Code. This is the only time in the history of U.S. tax law that a person under age 59 and a half can take money out of a 401k without a 10% penalty. But there is a catch that many 2026 taxpayers miss. The money must be taken directly from the 401k plan at the time of the QDRO transfer. If Samantha rolls the entire $350,000 into an IRA, and then decides a month later that she needs $50,000 in cash, the QDRO protection is gone. She will owe the 10% penalty. This is a step-by-step trap that catches thousands of Americans every year. The art of liquidity requires Samantha to calculate her cash needs before the money ever leaves the employer's plan. Then there is the complexity of the non-deductible basis, which requires IRS Form 8606. If Gregory's 401k contained after-tax contributions, those funds have a tax basis. In the world of art, this is like identifying which parts of the painting were made with expensive minerals and which were made with common oils. If the QDRO transfers a portion of the after-tax money to Samantha, she must receive a statement showing exactly how much of her $350,000 is tax-free basis. If she fails to report this on Form 8606, she will eventually pay ordinary income tax on that money when she withdraws it in retirement, effectively being taxed twice on the same dollar. Historical trends in 2026 show that the IRS is increasing its scrutiny of these basis transfers, as the move toward Roth 401k components has made the math more convoluted. We must also discuss the 3-year audit window. The IRS generally has 3 years from the date a return is filed to initiate an audit. This means Samantha's 2026 tax return, filed in 2027, is not safe until 2030. During this time, she must keep every scrap of paper related to the divorce, the final decree, the signed QDRO, the plan administrator's letter of qualification, and the 1099-R. Imagine if, in 2028, the IRS sends a CP 2000 notice claiming she owes $80,000 in unpaid taxes on the 401k transfer. This is a common scenario where the plan administrator's reporting does not match the taxpayer's reporting. Without the original QDRO documentation to prove the transfer was incident to a divorce, the IRS will default to the most expensive tax treatment possible. Step by step, the defense of the legacy also involves Form 5498. This form is issued by the financial institution that receives the rollover. It confirms to the IRS that the money was actually deposited into a retirement account. If Samantha moves the money from a 401k at Bank A to an IRA at Bank B, the IRS expects to see a 1099-R from Bank A and a 5498 from Bank B that match perfectly. If there is a discrepancy in the dollar amounts, even by a few cents due to trailing interest or administrative fees, it can trigger a red flag. Samantha must act as her own auditor, ensuring that the paper trail is seamless. Consider the case of an individual who receives a 401k split, but fails to update their own estate plan. Even after the 401k is safely in Samantha's name in a new IRA, the legacy is still at risk. If she has not filled out a new beneficiary designation for her new account, and she were to pass away, the state's intestacy laws or an old, forgotten will could direct that money to people she no longer intends to support. In 2026, the intersection of digital assets and traditional retirement accounts means that these beneficiary forms are often the only thing standing between a smooth transfer of wealth and a decade-long probate battle. As we master the final reporting and the defense against audits, we realize that the 401k is now a permanent part of Samantha's separate identity. She has moved from being a co-owner of a marital asset to the sole curator of her own financial future. But a massive question remains for many high-net-worth individuals in the United States. What if the 401k wasn't just a 401k, but was governed by a prenuptial agreement signed 15 years ago? Does the art of the QDRO override the art of the prenup? And what happens when a spouse discovers, years after the divorce is finalized, that the valuation of the 401k was based on fraudulent data or hidden accounts? In the next part, we are going to dive into the prenuptial masterpiece. We will look at how 2026 courts handle the conflict between private contracts and federal retirement law. We will also explore the reopening of the gallery, the rare and difficult process of returning to court to challenge a 401k split if fraud is discovered. We are moving into the realm of legal finality and the ultimate power of the documents that define our lives. The masterpiece is almost complete, but the most difficult signatures are yet to be scrutinized. The intersection of prenuptial agreements and federal retirement law is the final frontier of the 401k divorce masterclass, a place where private intentions often collide with the immovable wall of the Employee Retirement Income Security Act. In the legal landscape of 2026, this conflict has become a recurring theme in high-net-worth case studies. To understand this, we must look at the character of Alexander, a tech entrepreneur in Austin, Texas. Before marrying his spouse, Victoria, in 2016, Alexander insisted on a comprehensive prenuptial agreement. The document was clear. His 401k, then valued at $2 million, was to remain his separate property in the event of a divorce. Victoria signed the document, both parties had independent legal counsel, and the agreement was properly notarized. Fast forward to 2026, and the couple is finalizing their divorce. The 401k is now worth $5 million. Alexander assumes the prenup is his ironclad shield, but he is about to discover the ERISA superiority complex. The historical trend in United States federal courts is that a prenuptial agreement on its own is often insufficient to waive a spouse's right to a 401k. This is because ERISA specifically dictates that a spouse's interest in a retirement plan can only be waived by a spouse. When Victoria signed the prenup in 2016, she was a fiancée, not a spouse. Under Treasury Regulation Section 1.401-20, the IRS and the Department of Labor are explicit. A premarital waiver of spousal death benefits or survivor annuities is not valid. While some state courts have attempted to circumvent this by ordering the spouse to sign a waiver after the wedding, federal law frequently preempts these state-level maneuvers. Step by step, the only way Alexander could have truly protected that asset was to have Victoria sign a specific, plan-provided spousal consent form immediately after the wedding ceremony. Because they never completed this postnuptial step, Victoria may legally be entitled to 50% of the $5 million, regardless of what the prenuptial agreement says. This creates a scenario known as the contractual remedy. While Alexander might not be able to stop the 401k administrator from moving the money to Victoria due to federal law, he might be able to sue Victoria in state court for breach of contract based on the prenuptial agreement. This leads to a circular legal battle where the federal government gives Victoria the money, and the state court orders her to give it back. In 2026, the potential outcomes of these cases are highly dependent on the specific language of the prenup. A professional script for this agreement must include an affirmative obligation for the spouse to execute all necessary ERISA waivers post-marriage, and a liquidated damages clause if they fail to do so. Without these specific brushstrokes, the prenuptial masterpiece is often little more than a piece of paper when it meets the 401k. Now, we must transition from the creation of the agreement to the potential reopening of the gallery. This is the process of challenging a 401k division after the divorce is finalized. Imagine if, in late 2026, Victoria discovers that Alexander had a second, shadow 401k from a previous employer that was never disclosed during the discovery phase of their divorce. This is the art of the omitted asset. In the history of U.S. law, there is a strong preference for finality. The courts do not like to reopen cases once the final decree is signed. However, every state has a mechanism, often called a motion to set aside judgment or a petition for relief from judgment, to address instances of extrinsic fraud or material omission. The step-by-step process for reopening a case involves a high burden of proof. Victoria must prove that Alexander's failure to disclose the account was not a simple mistake, but a deliberate act of concealment that prevented her from having a fair opportunity to present her case. Historical trends in 2026 show that forensic data mining is making it harder to hide these assets. A forensic accountant can look at past tax returns, specifically the W-2 forms from previous years, to see if there were 401k contributions made to plans that weren't listed in the current financial affidavits. If Victoria can prove the omission, the court may not only split the hidden 401k but may also sanction Alexander by awarding Victoria a larger percentage of the asset or ordering him to pay all her legal fees. However, we must also consider the 5-year rule and the concept of latches. In many jurisdictions, there is a strict statute of limitations on how long you can wait to challenge a divorce settlement. If Victoria waits until 2031 to bring this to the court's attention, she might be barred from recovery, even if she has proof of fraud. The court may rule that she had a duty to perform her own due diligence during the original divorce. This is why the masterclass emphasizes the importance of the initial discovery. You cannot rely on the other party's honesty. You must verify the existence of every potential account through subpoenas to former employers and the Social Security Administration's earnings records. Consider an imagine-if scenario where the 401k was divided correctly, but a mathematical error was discovered in the QDRO 5 years later. Perhaps a decimal point was moved, or the gain and loss calculation was applied to the wrong dates. This is known as a clerical error, and it is much easier to fix than a case involving fraud. Most courts maintain a perpetual right to correct clerical mistakes to make the record speak the truth. But even a simple correction requires a new QDRO, a new submission to the plan administrator, and potentially a new round of administrative fees. The art of finality requires a level of precision in the original drafting that leaves no room for such errors. The 2026 reality of these cases is also shaped by the valuation of risk. If Victoria reopens the case to go after a hidden $200,401,000, but the legal fees to litigate the motion exceed $50,000, she must weigh the potential outcome against the cost. In the United States, the American rule generally means each party pays their own legal fees unless a specific statute allows for fee shifting. Reopening a case is an expensive, high-stakes gamble. This is the point where the art of the divorce meets the strategic reality of the settlement. Sometimes, it is better to have a slightly imperfect settlement that is finalized and protected by a QDRO, than to spend years chasing a perfect resolution that is eroded by the cost of the chase. As we reach the final layers of this masterclass, we have scrutinized the signatures of prenups, the mechanics of fraud discovery, and the difficult path to reopening a closed case. We have seen how federal law can override private contracts, and how the smallest omission can leave a shadow over your financial future. The 401k is not just a number on a statement. It is a complex legal entity that requires constant vigilance from the day you start your first job to the day you take your last distribution. But there is one final overarching truth that binds all these parts together. What is the one thing that almost every 401k holder in the United States forgets to do the day their divorce is finalized? And how can a single missing signature on a non-retirement document completely undo everything we have discussed in this series? In the final part of our deep dive masterclass, we will reveal the absolute final checklist for the 401k divorce. We will break down the residual risk that remains even after the money has moved, and look at the generational impact of how you handle this asset today. The masterpiece is finally coming into focus, but the varnish needs one last coat to stay protected for the next 40 years. We are entering the end game. The final varnish on our financial masterpiece is not applied in the courtroom, but in the quiet moments of administrative follow-through that occur after the judge has left the bench. In the art history of United States divorce, the most tragic figures are not those who lost the battle for the asset, but those who won the battle and then lost the war because of a missing signature on a non-retirement document. Consider the character of Jonathan in the year 2026. Jonathan has successfully navigated a high-conflict divorce in Colorado. His qualified domestic relations order was approved, and $500,000 was moved from his 401k into a new rollover IRA in his name. He has his own account, his own login, and his own peace of mind. However, Jonathan is living with a residual risk that could dismantle his entire legacy overnight. The first item on the absolute final checklist for the 401k divorce is the synchronization of the estate plan. In 2026, many individuals mistakenly believe that a divorce decree automatically revokes all legal ties to an ex-spouse. While many states have statutes that automatically revoke a former spouse as a beneficiary in a will, these laws do not always apply to every type of asset, and they certainly do not override federal ERISA law or the specific contract terms of an insurance policy. Jonathan may have won his 401k, but if his last will and testament still names his ex-spouse as the residuary legatee, and he passes away before updating that will, his ex-spouse could potentially inherit the very IRA he just fought to separate. Step by step, the professional maneuver here is to draft a new will, update your healthcare proxies, and revise your durable power of attorney the same week the divorce is finalized. Historically, the gap between the divorce decree and the estate plan update is the primary window for catastrophic inheritance errors. Next, we must address the beneficiary designation of the new account. When the 401k funds move into an IRA, the old beneficiary forms from the 401k are left behind. The new IRA is a blank canvas. If Jonathan fails to name a new beneficiary on his rollover IRA, the account will default to his estate upon his death. This leads to a potential outcome where the funds are subject to the high costs and delays of probate, rather than passing directly and privately to his children or heirs. In the context of 2026 tax law, specifically the ongoing evolution of the Secure Act 2.0, the rules for inherited IRAs have become significantly more restrictive. Non-spouse beneficiaries are generally required to liquidate the entire account within 10 years. To protect the generational impact of this asset, Jonathan must carefully coordinate his beneficiary designations with his overall tax strategy, perhaps utilizing a specialized trust if his heirs are minors or have special needs. The third pillar of the endgame is the Social Security optimization analysis. This is a hidden retirement asset that is often completely ignored in 401k deep dives. Under United States federal law, if a marriage lasted 10 years or longer, a divorced spouse may be entitled to claim Social Security benefits based on their ex-spouse earnings record, provided they are at least 62 years old and remain unmarried. The most critical detail here is that this does not reduce the benefit of the original account holder or their new spouse. In 2026, as the Social Security Administration updates its online portals, it is easier than ever to track these potential outcomes. Jonathan's ex-spouse may receive a significantly higher monthly check based on his 30 years as a high earner, and Jonathan loses nothing. However, if the marriage lasted 9 years and 11 months, that benefit is zero. Historical trends show that couples nearing the 10-year mark often delay the finality of their divorce by a few months specifically to capture this federal benefit, an artful piece of timing that can be worth hundreds of thousands of dollars over a lifetime. We then encounter the remarriage trap, a scenario that surfaces frequently in the art history of 2026 domestic relations. Imagine if Elena, who we followed in previous parts, decides to remarry in late 2026. She has her newly acquired 401k share safely tucked away. However, the moment she says "I do," her new spouse gains certain legal protections under ERISA. If Elena dies, federal law may dictate that her new spouse is the automatic beneficiary of any qualified retirement plan she holds, even if she intended for that money to go to the children from her first marriage. To neutralize this risk, Elena must have her new spouse sign a prenuptial agreement, and more importantly, a postnuptial ERISA waiver once they are legally married. Case studies indicate that failing to secure this post-marriage signature is the #1 cause of unintended disinheritance in the United States. The masterclass also requires a deep look at the Health Savings Account, or HSA. Often called the Mini 401k, the HSA is the only triple tax-advantaged vehicle in the U.S. Code. Contributions are tax-deductible, growth is tax-free, and withdrawals for medical expenses are tax-free. In 2026, as healthcare costs continue to climb, a high-balance HSA is a major marital asset. Unlike a 401k, an HSA does not require a QDRO. It is divided through a transfer incident to divorce under Section 1041 of the Internal Revenue Code. Step by step, the transfer must be handled as a trustee-to-trustee move. If the account holder simply writes a check to the ex-spouse, the IRS will treat it as a taxable distribution, and hit them with a 20% penalty. Mastering the HSA transfer is the final flourish in a complete retirement asset division. Furthermore, we must consider the generational impact of the cost basis. In 2026, forensic accounting has reached a level of precision where we can track the tax-deferred growth of an asset across multiple generations. If Jonathan leaves his IRA to his daughter, and she is forced to withdraw it during her peak earning years, the tax bite will be substantial. A strategic endgame involves looking at the 401k division not just as a split between two people, but as the foundation for a family's future. This might involve doing a partial Roth conversion of the 401k assets immediately after the divorce when Jonathan might be in a lower tax bracket due to the change in his filing status. By paying the tax now at a lower rate, he creates a tax-free legacy for the next generation. As we conclude this deep dive masterclass into the art history of 401k divorce in the US, we see that the masterpiece is never truly finished, it is simply preserved. The journey began with a dynamic disclaimer and the 1974 origins of ERISA, moved through the tactical drafting of QDROs and the defense against shadow accounts, and navigated the international waters of mirror orders and the hidden traps of tax forms. We have seen how a single comma, a missed signature, or a failure to understand the difference between a pre-tax and a post-tax dollar can change the course of a person's life. The 401k is the most significant financial monument of the modern American worker. To divide it is to perform surgery on a family's future. By applying the principles of valuation, tracing, and administrative precision, you move from the realm of the accidental to the realm of the intentional. You are no longer just a participant in a legal process. You are the curator of your own destiny. The varnish is dry, the documentation is filed, and the asset is secured. But as the world of 2026 continues to evolve, a new shadow is beginning to fall over the retirement landscape. What happens when these traditional 401ks are integrated with the burgeoning world of digital sovereign wealth? And how will the next generation of American law handle the division of retirement accounts that are held not in dollars, but in programmable assets that the IRS is only just beginning to define? The history of this art is still being written, and those who do not stay informed are destined to become the cautionary tales of tomorrow. Keep your eyes on the horizon because the next revolution in retirement law is already in the sketch phase.